Hi, it's Connecticut personal injury attorney Ryan McKean here. I'm here with Connecticut medical malpractice attorney Jake Kosianda. Hi, Jake.
Hi, Brian. How you doing?
I'm doing well, Jake. One of the things, I talk to lawyers from all over the country, and they often talk about like damages caps, which are basically the amount somebody can recover in any given instance. And, these come out of a process in the 80s and 90s and 2000s called tort reform, where essentially legislatures said, look, we're going to take away from the jury the amount that can totally be awarded to anybody has been injured. Can you explain in a Connecticut medical malpractice case, first of all, you can expand on what damages caps are. And second of all, are there any damages caps in Connecticut medical malpractice cases?
Sure. So damage caps are essentially a legislative law where the legislature says, if there's a medical malpractice lawsuit, we are not going to allow any award of damages beyond a certain amount. Now, there's different types of damages, and I'll talk a little bit about that in a second, but the reality is Connecticut does not have that cap. States like Texas and other states do have a cap, and they limit it to a certain amount. There's always been talk and rumblings within the legislature. The body of lobbyists for the medical community are always looking for caps. But the reality is in Connecticut, we don't have caps, which means the jury decides the limit and how much to award for compensation of a person's injury. Caps are usually related to the personal injury part, the non-economic, they call it, where it's amount of money someone should be awarded in compensation for loss of their health, whatever that happens to be. Anywhere from a loss of an arm, paralysis, your ill health, surgical removal of an intestine, things of that nature. There's no price tag on that. There's no limit where you can look it up on a chart and say, well, if you have lost a hand, this is how much you're entitled to. Or if you had to have abdominal surgery, you're entitled to this. Or if you're paralyzed or anything like that. The jury gets to decide, which means 6 people sit in a room, they talk about it, and they decide how much that patient lost based on the loss of their health, whatever that is. Then there's economic damages, and economic damages are a little different. Caps usually don't apply to those. Those are things like if you can't work anymore, how much money you lost over the remaining part of your labor life, your work life. You could have worked another 20 years, but you can't work anymore. You don't get those wages. You're entitled to those as damages. There are usually no caps for that, as well as future medical care and other care needed because of the loss of whatever health issue you have. If you're paralyzed and you can't walk, you'd be entitled to all the care in the future as a result of that, including wheelchairs, follow-up doctors, and augmentation or changes to your house or to your living arrangements so that you can function in life and be able to get around. There's no caps on those. Connecticut has no caps, so it doesn't apply to us in any context, but that's what caps are, and that's how they usually apply.
So, that's really important to know, because I think a lot of the dialogue in the country is, a lot of states have caps. Many states have caps, and particularly in medical malpractice. But in Connecticut, the Connecticut legislature has drawn the line, and they say, hey, it is the jury, not us, not the judge, who is in the best place to decide what money somebody may receive. So, look, it's a long way out there between wondering if you have a claim and, getting to a jury in a medical malpractice case. But if you have any questions, you can give Jake a call, 860-471-8333.